The rights of arrested person in India. Do the arrested persons have any legal rights? Yes, arrested persons also have some legal rights in our judicial system. In 1997, the Honorable Supreme Court in the case D.K. Vasu versus State of West Bengal issued some guidelines which were required to be mandatory followed in all cases of arrest and detention. Again in 2014, a landmark judgment passed by the Honorable Supreme Court in the case Kumar versus State of Bihar and issued important directions to the all state governments and to its police officers regarding arrest and detention. The Punjab and Haryana High Court observed the directions issued by the Honorable Supreme Court in the case Kumar versus State of Bihar with respect to the procedure for arrest shall be applicable to the offences punishable with less than or up to 7 years of imprisonment. In this case, the Honorable Supreme Court directed to all the state governments to instruct its police officers not to arrest any accused automatically when the offence is punishable with imprisonment for a term which may be less than 7 years or which may be extended to 7 years with or without fine. The police officer should maintain balance between the individual liberty and societal order while exercising the power of arrest under section 41, 41A and 57 of the Code of Criminal Procedure. When any person is arrested by police officers or any others in connection to an offence, the arrested person has certain legal rights during the course of any investigation, inquiry or trial of the offence for which he is charged, and he can protect himself against arbitrary or illegal arrest. Our legal system is based on the concept that innocent until proven guilty and works on the fundamental that let hundreds go unpunished but never punished an innocent person. Now come to the topic. The first right is right to know the grounds for arrest. This right is contained in section 50 clause 1 of the Code of Criminal Procedure and Article 22 clause 1 of the Indian Constitution. According to section 50 clause 1 of the Code of Criminal Procedure, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. It means when any person is arrested without warrant, he is entitled to know the full particulars of the offence for which he is arrested or other grounds for such arrest. Article 22 of the Indian Constitution also grants protection against arrest and detention in certain cases, as per Article 22 clause 1 of the Indian Constitution. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Regarding this right, other sections of the Code of Criminal Procedure also state that Section 55 of the Code of Criminal Procedure, when police officer deputes subordinate to arrest without warrant. Section 55 Code of Criminal Procedure says that when any person is being arrested by any police officer who is deputed by a senior police officer, then such subordinate officer shall, before making such arrest, notify the person to be arrested the substance of the written order given by the senior police officer specifying the offence or other cause for which the arrest is to be made. And Section 75 of the Code of Criminal Procedure relates to the notification of the substance of the warrant. According to Section 75 of the Code of Criminal Procedure, the police officer or other person executing a warrant of arrest shall notify the person to be arrested the substance of the warrant, and if so required shall show him the warrant. The next right is no unnecessary restraint. About this right, Section 49 of the Code of Criminal Procedure says that the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Next right is right to health and safety of the arrested person. About this right, section 55A of the Code of Criminal Procedure says that as per section 55A of the Code of Criminal Procedure, it shall be the duty of the person having the custody of an accused to take the reasonable care of the health and safety of the accused. Now the next right is right to be examined by a medical officer. Section 54 Code of Criminal Procedure enumerates this right and states that when any person is arrested, he shall be examined by a medical officer in the service of the central or state government, and in case the medical officer is not available, by the registered medical practitioner soon after the arrest is made. Provided that when the arrested person is a female, the examination of the body shall be made only by or under the supervision of a female medical officer, and in case the female medical officer is not available, by the female registered medical practitioner. After completion of the examination, the copy of the report of such examination shall be furnished by the medical officer or registered medical practitioner, as the case may be, to the arrested person or to any other person who may be nominated by the arrested person. Now the next right is right to bail. This right is contained in section 50 clause 2 of the Code of Criminal Procedure. According to section 50 clause 2 of the Code of Criminal Procedure, where a police officer arrests without warrant any person other than the person accused of a non-bailable offence, it means when any police officer arrests a person without warrant in a bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may be arranged for sureties on his behalf. Now the next right is right to meet an advocate of his choice. About this right, section 41D of the Code of Criminal Procedure says that according to section 41D of the Code of Criminal Procedure, when a person arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during the interrogation, though not through interrogation. About this right, the Article 22 Clause 1 of the Constitution also says that as per Article 22 Clause 1 of the Constitution, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Next right is right to inform about the arrest to the friends or relative or any other person of the arrested person. Section 50A of the Code of Criminal Procedure says about this right. As per section 50A of the Code of Criminal Procedure, obligation of the person making an arrest to inform about the arrest to a nominated person. According to this, every police officer or other person making an arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends or relatives or to any other person who may be nominated by the arrested person for the purpose of giving such information. The next right is right against self-incrimination. The Indian Constitution guarantees every person right against self-incrimination under Article 20 Clause 3 as per Article 20 Clause 3 of the Constitution. No person who is accused of any offence shall be compelled to a witness against himself. It means a person who has been accused of any offence shall not be compelled to a witness against himself. Again reiterated by the Honorable Supreme Court in the case Nandini Satpathy versus P. Aldani in 1917-8, wherein it was held that no one can forcibly extract a statement from the accused and that the accused has right to keep silence during the course of interrogation. The Honorable Supreme Court held that the objective of the Article 20 Clause 3 is to protect the accused unnecessary police harassment. The right against self-incrimination is available to the witness and the accused in the same manner, and it is applicable at every stage of the when the information furnished. The privilege of the Article 20 Clause 3 is applied at the stage of the police investigation when the information extracted. Again in 2010, the Honorable Supreme Court in the case Salvi versus State of Karnataka held that narco-analysis, brain mapping and lie detector tests are in violation of right against self-incrimination under Article 20 Clause 3 and their right to life and personal liberty under Article 21 of the Constitution. About this right, the Section 161 of the Code of Criminal Procedure also says that. According to Section 161 of the Code of Criminal Procedure, which relates to the examination of the witnesses by the police, Clause 2 of Section 161 Code of Criminal Procedure says that such person shall be bound to answer truly all the questions relating to such case put to him by such officer, other than the questions, the answer to which would have tendency to expose to him a criminal charge or to a penalty of forfeiture. The next right is right to be taken before magistrate without delay. This right is contained in Section 56 of the Code of Criminal Procedure. Section 56 of the Code of Criminal Procedure says that person arrested to be taken before the magistrate or before an officer in charge of the police station. According to Section 56 of the Code of Criminal Procedure, a police officer arrest any person without warrant shall, without unnecessary delay and subject to the provision herein contained as to bail, take or send the person arrested before the magistrate having the jurisdiction of the case or before officer in charge of the police station. About this right, Section 57 also says that the person arrested not to be detained more than 24 hours, according to Section 57 of the Code of Criminal Procedure. No police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not, in the absence of a special order of a magistrate under Section 167, exceed 24 hours, exclusive of the time necessary for the journey from the place of the arrest to the court of the magistrate. About this right, the Section 76 of the Code of Criminal Procedure also says that. According to Section 76 of the Code of Criminal Procedure, the person arrested to be taken brought before the court without delay. According to this section, the police officer or other person executing a warrant of arrest shall, subject to the provision of Section 71 as to security, without unnecessary delay, bring the person arrested before the court, before which he is required by law to produce such person, provided that such delay shall not in any case exceed 24 hours, exclusive of the time necessary for the journey from the place of the arrest to the court of the magistrate. About this right, the Article 22, Clause 2 of the Indian Constitution also says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours from such arrest, excluding the time necessary from the journey from the place of the arrest to the court of the magistrate. And no such person shall be detained in custody beyond the said period without the authority of the magistrate. But nothing in Clause 1 and Clause 2 of the Article 22 of the Constitution shall apply to any person who for the time being is an enemy alien, or to any person who is arrested and detained under any law provided for preventive detention. Now the next right is right to free legal aid and speedy trial of the cases. Right to get free legal aid is granted under Article 21 of the Constitution and amount to an essential elements of the reasonable, fair and just procedure. The Honorable Supreme Court in the case Hussain Aura Khatun and others versus Home Secretary State of Bihar and others in 1979. In this case, the Honorable Supreme Court passed a landmark judgment on speedy trial of the cases that come to be recognized as a fundamental rights of the every accused person. It is a facet of the rightful administration of the justice. The constitutional obligation upon the state to undertake the protection of the right of the individuals under Article 21 is inclusive of the duty to ensure there is a speedy trial of the cases. It also ensures the right to access free legal services to the poor as an essential part of Article 21 of the Constitution. Legal aid means giving free legal services to the poor and weaker section of the societies who cannot afford to take the services of an advocate to conduct a case or any legal proceedings in court of law or in any judicial authority or any judicial tribunal. Article 39A of the Constitution also provides that the state shall secure that the operation of the legal system promote justice on the basis of equal opportunities and shall in particular provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. About this right, the section 304 of the Code of Criminal Procedure also says that, as per section 304 of the Code of Criminal Procedure, legal aid to the accused at state expenses in certain cases, wherein a trial before the Court of Session, the accused is not represented by the pleader, and when it appears to the court that accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expenses of the state. Next right is right to fair trial. To assess fair hearing and fair trial of the cases in open court, the provision has been made under section 327 of the Code of Criminal Procedure. According to section 327 of the Code of Criminal Procedure, the place where any criminal court is held for the purpose of inquiring into or trying any offence shall be deemed to be an open court, to which the public generally may have access so far as the same can conveniently contain them. And to assess the deliver of judgment in open court, the provision has been made under section 353 of the Code of Criminal Procedure. Section 353 of the Code of Criminal Procedure mandates that the judgment must be delivered in the open court and read out in open court, or the operative part of the judgment we read out and substance of the judgment explained. About this right, the Article 14 of the Constitution also says that. Article 14 of the Constitution provides that the equality before the law or equal protection of the law within the territory of the India. It says that the state shall not deny to any person equality before the law or equal protection of the law within the territory of India. In order to make our judicial system strong, fair and transparent, the strict compliance of these rights is compulsory, which have been given to our citizens by Constitution and Code of Criminal Procedure, so that the test of the common people will remain on judiciary.